So there's a whole host of things that the CRT cannot resolve. And so they can't resolve anything other than those things that I talked about. But then they also give some specific examples of what they can't do. And I've sort of, it's quite a long list, but what I did was I kind of categorized them into different things. So it's certain disputes with landlords in a leasehold strata plan. So that won't come up very much unless you have a leasehold strata plan. And a leasehold strata plan is where somebody, like the city, for example, your municipality actually owns the underlying land, and when you it gets developed, and at the end, and there's a lease, and it can be for 50 years or 100 years, and at the end of that, there's a fee to be paid. So if you're a leasehold strata plan, you usually know who you are, but they're not very common. Disputes by or against former owners of the strata lot. So there's a civil resolution tribunal that says that the definition of owner under the provisions are current owners, the owners that are registered on title. So once they've stopped being registered on title, if they still have a dispute, like for example, they paid money in protest, for example, fines when they sold their unit, they need to have started that legal action before they sold the unit, because once they're sold, they're stuck going to either provincial court or Supreme Court, depending on the scenario. Certain matters that affect land, so ordering the sale of a strata lot, so if somebody doesn't pay their strata fees and you're wanting to force the sale of their strata lot, they have to go to the Supreme Court. Same thing with builder's liens, builder's lien disputes. If you want to get a builder's lien off title, that has to go to Supreme Court. And then court orders respecting rebuilding damaged real property. That's a situation where you have an insurance claim, and for whatever reason you're not repairing the damaged common property, you have to go to Supreme Court to confirm that plan. Dealing with developers in relation to subsequent phases and phase strata plans. So that's a strata corporation where it's going to be phased, but you haven't finished it. Again, that doesn't apply generally to most strata corporations, just some. Changes to owner's unit entitlement. So if you want to change the method for calculating strata fees, for example, that kind of a claim can't do that at the CRT. That has to go to Supreme Court. If you want to wind up a strata corporation or cancel the strata plan, again, that's Supreme Court. If you are a strata corporation that's trying to do a major repair and it's necessary to prevent, to ensure safety or prevent significant loss or damage, and you haven't been able to pass the 3/4 vote to raise the funds by special levy, but you're able to get more than 50%, you can apply to Supreme Court, and it's only Supreme Court, to get an order that the 3/4 vote was deemed passed. Same thing if there is a unanimous vote resolution that you want deemed passed. If more than 95% of the strata corporation's votes voted in favor of it, you can go to Supreme Court to get it deemed unanimous. If a council member is in a conflict of interest, and then that conflict of interest is discovered after the fact, and they've profited from it, for example, you can go to Supreme Court to ask for orders that sort of claws back some of that profiting. If the strata corporation is super dysfunctional and you need to have an administrator appointment, so somebody who runs or steps into the place of a strata council, that has to be done in Supreme Court, and the appointment of a voter when there's no person to vote a strata lot. So for example, if somebody dies and you don't have an administrator or an executor of the estate that steps in, that would happen. So again, this is more of the same. You've got just a civil resolution, things that can't be dealt with under the CRT process. They're set out in the provisions, and you'll get this in the slides. The only other thing that you sort of need to remember when it comes to these sort of court processes is that there is a time limit for starting claims. Right now, the current Limitation Act is that it's 2 years from the date that it's discovered, but you should also be aware that if the claim is arises before January 1, 2003, it might have a different limitation period. So it's not always cut and dry, the 2 years. Now, discovered has a specific meaning, and that's set out in Section 8 of the Limitation Act, and it's on the first day a person knew or should have known all those 4 aspects. So once that time period is expired, you're out of luck. And then finally, the last sort of place you might go is a Supreme Court or small claims court. Supreme Court, you're going to go if you have a contractual dispute that's above $35,000, negligence claims that are above $35,000, and then Strata Property Act claims that are outside of the CRT's jurisdiction. For small claims, you're going to have contract claims above $5,000, but up to 35, and same thing with negligence claims with a monetary value of $5,000 up to $35,000. That's it is essentially it, what you do sort of from a legal perspective. As I mentioned before, what you want to do is avoid the conflict in the first place so that you don't end up having to go through that conflict or sort of the formal court processes or tribunal processes to resolve the problem. If you can do that, you end up building community and keeping in mind that in order to do that, you should use some of the tools that Brian was talking about.